So I think Agnes, you give the prompter to Elodie as to when she should give the welcome remarks.
So we're going to start. I think we're online. Welcome to everyone joining this first webinar of the East Africa International Arbitration Conference, EAC. For those who don't know EAC, we created it about 8 years ago to promote arbitration in Africa. We usually have a flagship event, which is a 2-day conference every summer, which is the opportunity for literally hundreds of us to meet and discuss the development in arbitration in Africa and how to promote it. EAC 2020 was due to take place in Zanzibar this August, but obviously we're adapting to the current environment. So this will not be possible. But instead, we're starting a series of webinars. This is the first one today. And we'll hold EAC 2020 online on August 27 and 28 this summer. If you would like more information about the upcoming webinars and EAC 2020, you can visit our website, and I'll post shortly the link on the chat, and you probably have it in your email confirming your registration today. With that, I'm going to pass the mic to Warimu Karanja, who's going to be our moderator today. Warimu is one of my fellow members of the EAC organizing committee. She's a director and a lead consultant at W&Co in Nairobi, and she has been recently recognized as a future leader in arbitration by Who's Who Legal. Warimu.
Thank you very much, Elodie. Ladies and gentlemen, welcome once again to our first EAC webinar, which is going to be on current developments in international arbitration in Africa. I'll first start off with housekeeping issues before I introduce my panel. And I would like to introduce you to our background EAC members, Steve O'War, who is going to be running us through the housekeeping issues. So, Steve, if you can move on to our next slide. All right, so before we get that slide on, I'd like to touch on a few housekeeping points, which is that you are joining the webinar You are all muted as participants. However, there is thank you. So there is a Q&A panel in which you can ask your Q&As at any time during the presentation. So there's a live chat and there's a Q&A panel. And we are also going to be having polls and surveys. The poll question will be shared in the course of the presentations, and we will have a survey at the end of the webinar. We are live streaming on YouTube and on Twitter Live, so please join us. The webinar is being recorded, and the recording is going to be shared at the end of the webinar. We are very happy to have several countries, members from participants from several countries joining us. As you can see on that slide, we've got participants as far as Angola, Austria, Ghana, France, Germany, Italy, Qatar, Norway, the US, Switzerland, and even Russia, Rwanda, Senegal, and a lot of participants from Kenya, Nigeria, Tanzania, and the UK, Uganda and Ethiopia as well. Thank you for joining us. We are also very happy and are thankful to have participants joining us from various organizations, including law firms, arbitration institutions, government offices, and private sector companies, including energy companies, telco companies, attorneys general offices, judiciaries. So thank you very much for that. Now I'd like to then move on ahead to introduce my panel. We're going to have as speakers Mr. Kamal Shah, who is the partner at Stevenson Harwood LLP in the UK. Kamal is head of both the India and Africa groups at Stevenson Harwood, and he's been a supporter of the EAC conferences for quite a long time. He has been recognized by various legal directories as a leading lawyer in arbitration and in dispute resolution, including the Legal 500, including Chambers Global, among others. We also have Madeleine Kimei. Madeleine Kimei is the founder and senior partner at iResolve. iResolve is a very, I would say, innovative law firm in Tanzania that specializes on dispute resolution and corporate advisory. And she has also been recognized as a leading lawyer, especially when it comes to arbitration and digital legal solutions or legal tech. We also have Terry Mwango, who is a dispute resolution and arbitration partner at Kenyan law firm Coulson Honey LLP, which is part of the Bowman's Group. And Terry has been recognized by leading directories as a leading lawyer in dispute resolution, including Legal 500 and Chambers Global. We also have Leyu Tameru. Leyu Tameru is a fellow co-organizer of the East Africa International Arbitration Conference with myself, Agnes Gitau, and Elodie Dula. Leyu is head of iArb Africa, which is an online platform for arbitrators and arbitration information. And she's also a member of the ICC Court, the International Chamber of Commerce Court of Arbitration. Our last speaker is going to be Mr. Johan Rajabali, who is a senior legal executive at BLC Robert in Mauritius, and who is also recognized as a leading lawyer in arbitration and dispute resolution in Mauritius. So welcome to all my speakers. Thank you very much for making time and for joining us on our first webinar. It's a first of several webinars that we're going to be running since we will not be having the physical EAC conference at the end of August, but we're going to be running a series of webinars. With that introduction, I will start off with Kamal Shah from Stevenson Harwood to talk about his experience when it comes to fraud and corruption in international arbitration. Kamal, I know he's been involved in a lot of cases, including cases from Nigeria, including enforcement in the UK. Tell us, how prevalent is fraud in international arbitration, and at what stage does it manifest itself?
Thank you very much. Good afternoon, everyone. I think it's important to start with the history. Historically, we haven't seen as many fraud cases ending up in the courts. And it's really in the last decade or so that more and more arbitrations post-award end up in a very, very long enforcement battle. And it is often at that stage where those cases end up in the courts and fraud starts to emerge. We start to know about the fraud in the underlying arbitration. So I think because more and more cases are going to the challenge stage, that's why we're seeing more fraud cases. It may be that they were prevalent before, but because of the confidentiality, we didn't have as much visibility. The other reason is that there are much better techniques now available to detect fraud and to prove fraud in a number of different scenarios, whether it may be to do with forgery of signatures or manufacture of documents, contracts, invoices, etc. The techniques are much more scientific and accurate. And the other reason is also the amounts are so much larger nowadays. To see a case worth several $100 million or indeed several $1 billion is becoming more and more common. Many of those relate to industries like the oil and gas infrastructure, where necessarily the amounts are larger, but because the amounts are larger, parties are prepared to fight harder and invest time and money in challenging the award, often discovering fraud along the way. I think another reason is also the idea of fraud is no longer taboo, whereas in the past there was a reluctance amongst whether it was governments, corporates, or other entities to face up to the fact that they may be the subject of fraud or that there may be fraud internally. People are no longer apprehensive as such to detect it and to fight it. In terms of what stage it manifests itself, it's really variable in my experience, and I'm sure the others share this. It can manifest itself at the very start of a contract when it's awarded. The obvious case there is a contract is procured because of an illicit payment. It can manifest itself before an arbitration, whereby documents are manufactured in order to put up a claim. Or a little later down the line, during an arbitration, where documents may be inflated at the stage of damages. Documents may be manufactured to inflate the claims. And the obvious documents there are invoices, purchase orders, manufactured contracts, particularly in industries like construction, infrastructure, oil and gas, where there are many different suppliers to a project. It is quite prevalent there in some cases. And of course, at the end of an arbitration, once it is all concluded, an award has been rendered and the tribunal is functus, a party may discover that it was the subject of fraud. It may be looking at the documents submitted in the arbitration and discover fraud. Or there may be a whistleblower from the other side, the winning side perhaps, who is disgruntled and comes across to the other side and says, actually, these documents were manufactured. So there's a whole range of scenarios as to how fraud emerges. And we generally see fraud emerging during an arbitration or after the arbitration. It's quite rare at the contract stage for it to suddenly emerge. Thank you.
All right, well, thank you very much, Kamal. I have a couple of follow-up questions, but before then, I'd like to just tell the participants that Kamal is also in the LCIA Africa Users Council, and so he will be leading this webinar early, so that he can attend the LCIA Users Council webinar, the LCIA webinar that is happening shortly. So we have some takeaway points from Kamal that are showing on the screen share. And while that is running, Kamal, kindly let us know what is the impact of uncovering fraud, and at what point would you say it is too late to uncover fraud?
Thank you very much. In terms, I'll take your second question first. It's never too late, in my view, to uncover fraud, because even if an arbitration is concluded and you have paid up on an award against you and you suddenly discover fraud a few years later on, it is still possible to unravel and pursue those who you paid, who were the perpetrators of the fraud. Obviously, the earlier the better, but fraud by its nature is such that it tends to hide away for years and years and then suddenly emerge in unexpected ways. The impact is a bit obvious where you discover it, you investigate it, and then you prove it conclusively. It allows you to challenge the underlying award and to try and unravel all of it or parts of it, and gives you an upper hand in negotiating a settlement as well. Not all awards will be set aside because of the difficulties of doing so, but many could be settled in an amicable way if you are able to produce good evidence to show that there was fraud. And the obvious answer to all of that is you want finality, and the tribunal is functus. So you do have to go to the courts or talk amongst yourselves to come up to a settlement. Thank you.
All right. Thank you very much, Kamal, for that. I'll now follow up with just a follow-up question to speakers from two countries that have had quite an experience when it comes to fraud and corruption. Madeline from Tanzania, tell us what your experience very briefly has been, or what Tanzania's experience has been with fraud and corruption in arbitration.
Thank you, Wairimu, and good afternoon to you all. Well, my experience with fraud in arbitration was when I took part as an arbitral secretary in a telecommunications dispute. Now, what happened there was one of the parties claimed that there was a manufacturing of documents. And there was a sort of mismatch on what was being produced through the production of documents process that was being undertaken through that proceedings. And so therefore, that's where I came about fraud in the aspect of fraud and forgery in a particular arbitration or dispute that is pending in an arbitration. Now, what happened there is that the tribunal took a very surprising approach, which I wasn't anticipating, which was that, yes, they noted the allegations that were alleged by the claimant as opposed to the against the respondent. They also noted that they were unable to rule or to deliver a ruling on the aspect of fraud due to the lack of evidentiary proof that had been tendered through those proceedings. And so that's really my experience when it comes to fraud in arbitration. But adding on to that, because my discussion today is on the new Arbitration Act. Now, the old Arbitration Act, which is the CAP 15 revised edition of 2002 in Tanzania, had no provisions providing for any guidance with respect to challenging an award that has elements of fraud or serious irregularities. And now in this new act, which makes reference to serious irregularities under Section 70, subsection G, one can rely on the aspects of fraud having been an element of those proceedings. And furthermore, also on the enforcement aspects under Section 78 of the new Act. Yes.
All right. Thank you very much, Madeline. And very quickly, Terry Mwango from Kenya, perhaps you can let us know in a minute what your experience or what you've seen has been the experience when it comes to fraud and corruption in arbitration.
Thank you, Irimo. Good afternoon, panelists and attendees. I'm excited to see that the crowd keeps growing. I'll be very brief. So I think most of us have heard of the ICSID arbitration world duty-free case. It's a Kenyan case against the government of Kenya, and that was the first decision where it was held that an illegality could be the basis for setting aside or dismissing a claim, rather. That, of course, was a landmark decision, not just for the Kenyan space, but I think in terms of international arbitration, because it set the stage or contributed to the thought that, if there has been a fraud, as Kamal had explained, whether it's in the initial stages of the negotiation of entering into a contract or in the performance of that contract, then arbitrators or tribunals will not shy away from dismissing claims where a claimant is seen to be trying to benefit from an illegality. And of course, there's also the Cortex mining case, which similarly was also dismissed on the basis of an illegality. So I think what is coming through very clearly in the decisions that have been given by our tribunals, whether in domestic or international arbitrations, is that arbitrators will not shy to set aside, to dismiss claims where it has been demonstrated that the law has been broken in whatever way, shape, or form.
Thank you very much, Terry. Iyak, if we can just have the slide that has Kamal's takeaway points, I'd like for us to have the participants just share a little bit. Now, you'll see from that slide, Kamal Shah has given us a very good background as to how fraud manifests itself in international arbitration. And of course, if you have any further questions on fraud and corruption in international arbitration, please feel free to ask Kamal on the Q&A. And there will also, his details are on the IAC website, so you can also contact him directly. Thank you very much, Kamal. Before we move on to the next speaker, we have a poll question that is going to be run very shortly by the IAC team. And that question is on the African cities that you would choose as a place of arbitration. Of course, again, considering whether it's a place that you can, trust the judiciary that has the technology, which African city would you choose from among those that are provided for in the poll question? All right. And with that, I think results will be displayed very soon. The winner is going to be displayed very soon. We are now going to thank you very much, Kamal, once again for your contribution on fraud and corruption in international arbitration. And I know we'll be hearing further from you as we go along. Oh, yes, I can see that Nairobi seems to be the biggest taker. I think there are some Nairobians who might have voted twice. I don't know. But let's move on to Madeline Kimei, who is from iResolve, Tanzania. Madeline, Tanzania recently put in place a new arbitration act. Please tell us a little bit about that, and also what progress you have seen with regard to the adoption of the ancestral model law.
Thank you, Wairimu. And I didn't see Dar es Salaam there, so I'm a bit, pushed back. So I didn't pick Nairobi. Well, with the new Arbitration Act, it's okay. With the new Arbitration Act, really the background comes about the fact that we had a really ancient act in place that dated back to 1931. And with this new Arbitration Act, which came into force on the 21st of February 2020, repealing and replacing entirely the old regime that we had in place. And so therefore making a radical change in the approach to arbitration in Tanzania. Now, the act is also being applied retrospectively. And so therefore, this would be applying to arbitration agreements, pending arbitrations and awards prior to the act coming into force. And so therefore, we welcomed the enactment of this particular legislation, because we had lagged behind on now becoming a pro-arbitration jurisdiction in terms of having a robust regulatory framework backing up what was coming out of our judiciary, which was very pro-arbitration prior to this 2020 Act. And so now we have a comprehensive statutory framework that has gone away from the old edition and has somehow implemented or reflects the UNICIT model law, but not to the letter. Not to the letter at all. We have taken the English approach, the UK Arbitration Act of 1996. It is a copy and paste, or if I can say a sort of a copy and paste of the English Arbitration Act 1996. So we really have to be cautious, because we are applying this this very comprehensive, robust act in an environment where, in our jurisdiction, the practice of arbitration is yet to reach fruition. And so therefore, we're very much at our infancy in respect to the practice of arbitration. And so therefore, we're waiting to learn from what will be coming from the courts as we implement this particular new legislation. And so therefore, I think I'll stop there, just to give more time to the question and answer period.
All right. No, thank you so much, Madeline, for that introduction. Now, why don't you tell us a little bit about how the judiciary has taken on to the new Arbitration Act, if at all, and also in your past experience, there have been sometimes complaints about whether they are pro-arbitration or not. What has been your experience? You're still on mute.
So sorry about that. So far, really, we have not seen the play yet from the judiciary, but traditionally, as I said prior, the judiciary has been very pro-arbitration. And so in our opinion, the new act would be applied in the means of also borrowing from the precedents coming from the English courts, as we have usually done. And so therefore, we are expecting a more I guess a smoother run with respect to the practice of arbitration, the enforcement of arbitral awards, and of course there's an element of the new act which is limiting the court intervention. And so then we embrace that, because of the fact that now this would open up to such expedited proceedings, arbitration proceedings, whether be it ad hoc or institutional. If we look at the provisions of the Act, we can see a reduced approach to court intervention in several areas. Now, of course, there's the challenges of that I spoke of with respect to serious irregularity provided for under Section 70. We've also spoken about on the issue of enforcement, and we also have a new section which is introducing an aspect which is new to us, which is the appeals on points of law. Now, this is much more common in the English courts, and so we are waiting to see how our judiciary would approach this particular section 69 and 71 of the Act. Further to that, there are aspects of non-interventionist approaches, such as the doctrine of separability, which is provided for under Section 10. And that is really just some of the elements that we are waiting to see or learn from our judiciary for us to have that precedence build up. And so then we could have those lessons learned that you've just asked me about.
Thank you very much, Madeleine. And I think in discussing that, you've also taken care of some of the questions that I've seen in the Q&A, which is what the salient provisions of the Arbitration Act are, and also whether it deals with issues that are otherwise covered in the English Arbitration Act. And you've mentioned the issue of serious irregularity and points of appeals on points of law, which I think had questions from our Q&A. Now, I'll then just ask you very quickly to talk about the Tanzania Arbitration Center that has been established under the Act. What is the fate of the center? What should we expect to see? And what is the fate in terms of perceived neutrality?
Well, the Tanzania Arbitration Center has been established under the Act. It's under Section 77 of the Act. Now, the establishment of this center really came as a surprise. It's established as a body corporate with perpetual succession and so on, and so therefore this is a body that would have would be expected to be independently sort of instituted by the government. Now, because the function, I'm saying by the government, because most of its functions, especially on the governance structure, include an aspect of ministerial control, and considering that ministerial active control of the government within this particular establishment and its operations, then we, in my preliminary opinion, we see that there could be lack of neutrality of this particular center. Now, from my knowledge is that nothing has been done so far. So the Tanzania Arbitration Center has not yet been established. No committee has been set up to drive this at this moment. And so therefore, it's still really just on paper. And what we would say as practitioners, we would wish for that to be reevaluated and reassessed, and for the government to think of a more hands-off approach to the particular establishment of this center, or to use those institutions that have been around for over 10 years in the country, such as the Tanzania Institute of Arbitrators and the National Construction Council, which have been really spearheading the administration of arbitration proceedings in the country.
Thank you very much, Madeleine. I'll look to you, Johan Rajabali from Mauritius. Just following on from Madeleine's discussion about the adoption of the ancestral model law in Tanzania, what has been your experience of adoption of the ancestral model law in Mauritius?
Thank you very much, Mariamu, and good afternoon, everyone. Mauritius, there has been a concerted effort here in Mauritius from the lawmakers and from the judiciary to put Mauritius on the map of international arbitration. And that came via a set of legal framework in line with international model law, and which encourage a harmonious existence with a court. So the overwhelming view here in Mauritius is that the court has rather act in support of arbitration, and that has come through its case law, who showed a determination, if I may say so, to hold the aim of the parties to act through arbitration as opposed to go to court, and this is in line with the competence principle, which we can see in all international states.
All right, thank you very much, Johan, and thank you, Madeline, for your very great discussion on the Tanzania Arbitration Act. EAC team is sharing some takeaway points. We'll share some takeaway points from Madeline's presentation, which should be showing on screen now. As you can see, is sharing. As you can see, the Tanzania Arbitration Act, it should be showing on screen now. As you can see, is sharing. As you can see, the Tanzania Arbitration Act, it should be showing on screen now. As you can see, is sharing. As you can see, the Tanzania Arbitration Act, it should be showing on screen now. As you can see, is sharing. As you can see, the Tanzania Arbitration Act, it should be showing on screen. I apologize. I think I may have had some sound issues on my end. So sorry about that, but I hope you noted the takeaway points from Madeline Kimei. The Tanzania Arbitration Act is not structurally based on the ancestral model law, but it has very good elements of that. There is a risk of perception of the Tanzania Arbitration Center having some government influence, but it is still very early stages. And all centers, especially African centers, have to go through some form of support, but we will be seeing a lot more independence as operations continue. Now, I will then now invite Terry Mwango from Kenya. Before Terry Mwango speaks, I'd like to remind everyone, all the participants, please keep your questions coming. We do have a Q&A session at the end of this presentation, at the end of all the presentations, sorry, and answers will also be answered on the chat and on email. So, Terry, it's my pleasure to welcome you to talk about your African and Kenyan experience of virtual proceedings and virtual meetings. Please let us know, are they the new normal? Are they here to stay? Is it a stopgap measure because of COVID? What have been your lessons? Welcome, Terry.
Thank you. Thanks very much for that introduction. I certainly don't think that from a Kenyan perspective, COVID-19 has been a stopgap measure in relation to the reaction that various tribunals and our judiciary have had. So, for example, from a domestic perspective, I'll first look at the domestic arbitration space. We have had virtual proceedings going on, of course, as a consequence of COVID-19, and pursuant to the public health regulations that were passed by the government of Kenya in early March, soon after the pandemic was declared, prohibiting, among other things, the gathering of more than 15 people in one place at a time. That then resulted in various guidance notes being issued. we also know that the Chartered Institute of Arbitrators issued a guidance note on the 8th of April this year, and that has been adopted by the local chapter, the Kenyan chapter, which has then facilitated the virtual proceedings or the remote hearings of matters. So from a domestic arbitration perspective, we have seen arbitrators continue to hear matters where parties have consented. And that's one of the things that I think has been a takeaway is, for example, where proceedings had commenced in domestic arbitrations, some parties have been reluctant to proceed with the matters where they've been asked to proceed remotely. And that has actually been a very interesting thing to watch. For example, where a party is a respondent and they have then taken advantage of the situation to say, they would prefer to have face-to-face proceedings, and therefore they would want the matter to be held in abeyance until such time as a physical proceeding can be held. So that's actually been interesting to watch, and I think perhaps is a takeaway for tribunals and arbitrators where a party is seen to be obstinate purely for the fact that they don't want a proceeding to continue. From the perspective of the Nairobi Center for International Arbitration, the offices have remained closed, again, because of the public health regulations prohibiting gathering of people. But they have continued to allow e-filings, and they have continued to allow for queries or engagement on a remote basis. And then in relation to court proceedings, this is something that is very near and dear to my heart. So the courts in Kenya, I think, have responded fantastically, to the issue of the challenges faced by COVID-19 in terms of practitioners and parties and members of the public not being able to attend court physically. So our Chief Justice issued various practice notes, and our various divisions of our judiciary have also issued various practice notes, as they have continued to watch the situation with COVID. So for example, for the last almost 2 months now in Kenya, we have virtual proceedings for our court matters. That means, we're able to attend court, we are still able to have matters continue, whether it's mentions or applications. Some hearings have now actually taken off on a virtual manner, and that's been quite exciting to watch. Not only that, with effect from the 1st of July, which is just a couple of weeks away, mandatory filings, or rather, e-filings are now the only way that you can file documents in Kenya. In Nairobi. So, you will no longer be able to go to the registry in Kenya to file documents physically. Of course, the other flip side of that is litigants, for example, who are acting in person, who may not have access to technology. What does that mean for them in terms of being able to access justice? And access to justice is actually one of our constitutional principles that, the courts are encouraged to facilitate not only just, but also expeditious facilitation of service. So it'll be interesting to see how the response to e-filings will inevitably have an impact to people who don't have access to that kind of technology. The thing that has also been quite landmark in Kenya is the fact that our judges have risen to the occasion in being able to respond to the challenges that COVID-19 has resulted, for example, in the boardrooms. So my firm was instrumental in being able to file a novel case in the High Court in Kenya under Section 280 of the Companies Act to seek the leave of the court to allow a company to hold a virtual extra general meeting. That had never been done in Kenya before. And our courts not only gave leave for that application, or rather for that extra general meeting to be held, but went a step further and then allowed that order to apply to any other public listed company that would need to hold a general meeting, but is unable to do so because of the COVID-19 restrictions. We have also approached the court on behalf of a public company that is a bank. So we have seen that the courts in Kenya are not only responding to the fact that they are now holding proceedings virtually, but they have been able to apply the law in a manner that is purposive and acknowledges the fact that there are certain challenges that whether it's companies or practitioners are facing. So I think in terms of the development of company law in Kenya, that has been quite exciting to see. And we have also seen a lot of companies now start to amend their articles of association to allow for virtual proceedings in terms of their general meetings or extra general meetings. Something else that has also been that has happened in relation to the COVID-19 situation. Some of you may have seen, especially my Kenyan colleagues, that we now have draft CIAB Kenya branch arbitration rules 2020. And by the proposed rules 51 and 52, virtual proceedings will now be provided for. So to go back to your initial comment, Wairimo, as to whether or not from a Kenyan perspective, the COVID-19 virtual proceedings or remote proceedings is just a stopgap measure. I don't think it is, particularly because, the judiciary in Kenya has for a long time now been moving towards digitization of proceedings. So this is certainly something that they have not only stepped up and accepted and demonstrated the ability to facilitate, but they have gone a step further and taken it as the norm, for example, as the e-filings. From the international perspective, in relation to international arbitrations, again, the firm we've just concluded an LCIA international arbitration. And this one was actually quite exciting to see because the core team was in South Africa, so in our South Africa office. The subject matter of the arbitration was in Nairobi, Kenya. We had expert witnesses from different parts of the country. The arbitrator was sitting in Kent in the UK. We had an expert witness from Germany, and we had witnesses from Nairobi, Mombasa, and the respondent was in Pakistan. So, in speaking with the team that was handling this, it was quite interesting to see that they had, absolutely no technical hitches. So from a perspective of being able to have a very seamless run of proceedings, that went on very well. The proceedings were held via the Zoom platform. And what they also did was that they brought in a third-party intermediary so that when there was need to have breakout sessions, then the intermediary was able to put people in the breakout rooms. And I think this is quite important, especially where a witness is in cross-examination. One of the things that, of course, one would ask is, ordinarily, if it's a physical hearing, all practitioners would know that you're not supposed to interact with the witness in the manner that you'd be, perhaps trying to be helping them with their cross-examination. So for example, in this particular international arbitration, what happened is that then the breakout rooms, that witness would not be put in the breakout rooms with the rest of the team. So just in conclusion, I think there's certainly a new normal, and that's virtual proceedings. I think for us, practitioners, arbitrators, colleagues, there's certain takeaways that we need to have. One of the things that I think, is going to be a mandatory requirement is, for example, etiquette. How do we appear before the tribunals, before the courts? I think, certain dress codes are going to be enforced. The technology that's to be employed, for example, from a Kenyan perspective, certain courts have preferred to use, or certain judges have preferred to use certain platforms. So, we're seeing Microsoft Teams, we're seeing Zoom, even from an arbitration perspective. So I think going forward, those are the kind of things we would need to look into. How do we standardize the appearance from a virtual perspective? Because then there needs also to be consistency. There needs to be consistency in the form of technology that's employed, not just by us practitioners, but also by the various tribunals and arbiters. Thank you very much.
Thank you very much, Terry. You've actually dealt with the follow-up question that I had for you, which was how, when you're cross-examining, especially for most legal practitioners, the worry of adopting online proceedings has been, well, you can't tell the telltale signs of when a witness is not being upfront. You can't check the body language. And it's interesting that you mentioned the LCIA arbitration that you just concluded. Was that, perhaps you can quickly tell us whether the whole issue of cross-examination of witnesses and the fact that there's a screen in front of someone and they can compose themselves if they want to, was that a hindrance at all for you?
So there wasn't any hindrance, but then that boiled down to good connectivity. So, all the parties, the tribunal was still able to watch things like body language. So from that perspective, there was nothing lost in terms of being able to make certain observations. However, if there's connectivity issues, of course, then there's going to be a challenge because you will not have the benefit of being able to read certain body language that would be very useful in being able to take away certain reactions or demeanor of a witness.
Thank you very, very much, Terry, on that. I'll move on to Leyu. Just a quick commentary on online proceedings. Terry has mentioned what her experience has been with LCIA arbitration. And we have Terry's summary points on the screen, which is that virtual proceedings. Terry has mentioned what her experience has been with LCIA. Leyu, what is your experience from an ICC court perspective? You're a member of the ICC court.
Thank you so much, Wairimu. I'm glad to see so many people have joined this webinar. It's quite exciting. From my experience, at least what we've seen at ICC is that ICC, as many other arbitration centers, has issued a guidance note on virtual hearings. But from an internal view, outside of the the arbitration disputes, having virtual hearings, what I can tell you the impact it has had on court members and court hearings is that we are now more virtual than we used to be. Previously, plenary sessions had to be held in person in Paris or in one of the offices of the ICC, whether it was in Brazil, in the US, or in Asia. We are now experiencing the capacity, at least having the capacity to be able to attend plenary court sessions without having to go anywhere, which is great because it increases participation of court members from all over the world. It's cheaper, but it's also it was a challenge because that's where decisions are passed. For example, appointment and challenges of arbitrators and challenges that come up during disputes. So it's been quite a great experience, at least on our end.
Sorry, I muted myself there. So thank you. It's very good to hear your perspective on what it's been generally and also at the ICC court. Kamal, I know you have to go very soon, but I'd like to ask your specific experience. I hope I'm not letting anything on in saying that you've been based in Kenya since COVID-19 happened, and you've obviously had to deal with international arbitrations. What has your experience of online proceedings been, number one? And number two, pursuant to your discussion on fraud and corruption, what are the kind of loopholes that you can see coming up in online arbitration or online dispute resolution, and how can we avoid them? If you can just make quick commentaries on those two issues.
Sure, thank you, Wairimu. In terms of our experience, we have, like everyone else, used lots of different platforms in the last 3 months for arbitrations, for court hearings, whether it's Zoom, it's Skype, it's Ring Central, Teams even, number of variations. The preparation and the testing is obviously key, as is the bandwidth and all of that. I think we're all probably past that now. We figured out how to try and do it properly. we can't control all the hitches and the technical glitches whilst we're in the hearing. The bigger issue I think we will see, not now, not in the next quarter or two, but probably in the next 9 to 12 months or longer, is parties who have lost, and perhaps parties who reluctantly agreed to having online hearings or were forced to by the tribunals, going to the courts of the enforcing jurisdictions and saying, look, judge, these are the issues we faced. These are the objections we made. These were the orders we were subjected to, forcing us into a virtual hearing. Therefore, this award should be set aside, sent back to the arbitrators, or any number of variations there. Who knows, there might even be some public policy arguments around this. So I think it's a bit early to say it's working very well, because the technical side may be working very well. But the real issue, I think we will find in a year or so, when you do a follow-up in person back in Zanzibar, I hope, is we talk about this and what has happened since all these online hearings, which either worked or didn't very well. So that I think we can only wait and see. In terms of fraud and anything untoward in these virtual hearings, whilst you can see me now, you may not be able to see the other two screens around my laptop, where I may be feeding the witness tips. As soon as the eyes go up, you don't know. So there are, I think, real concerns around untoward behavior in hearings. By and large, I think if you have good representation, those can be avoided because of good ethical behavior and the like. But I don't think you can discount the possibility of other things creeping in. The third point I'll just make is in terms of our experience with the UK court systems. We have had good experiences. The issue we've had is not being able to see all the judges at once, for example, or all the counsel team all saying or interrupting one another. The body language, I think, suffers. So those are my observations.
All right, thank you very much, Kamal. The IAC, so those are all very interesting perspectives, and that leads us to our next poll question, which is going to be run by the IAC team. It should be showing on screen now. And this is a lead up to Terry's discussion. In the COVID-19 era, do you think arbitrators should hold a virtual hearing if one party objects and requests a physical hearing? So we are going to run that poll for about 30 seconds. Well, 10 seconds now. So get your yes or no answers in as we are going to end polling shortly. And from what I can see, the yeas are having it that, oh, hang on, now we're at 50-50. Goodness me. Okay, do you think arbitrators should hold a virtual hearing if one party objects and requests a physical hearing? Terry Mwango, please give us your final comment based on that poll question. And I must say the yeses have it.
Thank you, Irimo. Well, I'm in the no camp. I don't think that just because virtual proceedings are the new black, as it were, at the moment, that if one party requests a virtual hearing and the other party requests a physical hearing, that then the tribunal should insist that a virtual proceeding continues. Of course, with the rider that, as I'd mentioned earlier, there could sometimes be a party who's simply trying to take advantage of the situation to delay a matter going on. I think if there's a valid reason for requesting a physical hearing, or if a party is able to explain why they would be prejudiced by having a virtual as opposed to a physical hearing, then I think then the tribunal would have to respect party autonomy.
Thank you very much, Terry. So Terry is in the no camp, but the yeses seem to have it. So that is an issue for also arbitrators to think about. It will be one of the issues that will be subject to very heated discussions when it comes to objections in hearings. I'd like now to invite Leyu Tameru on our next issue of hot topics in international arbitration in Africa, which is one of the hot topics of the Ethiopia ratification of the New York Convention. Leyu, IAB Africa, I know you've been very involved in this. I know you've been very involved in the process. When are we expecting accession, and what do you think are the challenges that lie ahead in enforcing the New York Convention in Ethiopia?
Thank you, Erimu. That's a bit of a difficult question for legal reasons, and I'll explain very quickly. So in order to domesticate the New York Convention, the Ethiopian, well, under, as required under Ethiopian law, there is now a proclamation that is the ratification proclamation of the New York Convention, and that proclamation has a few, for example, reservations and declarations that it has made with regards to the New York Convention. So the first one is, as Ethiopia ratifies it, we've been very clear about making two major declarations that you can make on the New York Convention. The first one is the reciprocity element, which very much is like Kenya, UK, France, US, and whatnot, where you will only enforce the awards from coming from countries that are themselves signatories of the New York Convention. And the second one is obviously the commercial reservation, which is we will only enforce awards which concern commercial cases as per the definition of the national law. Now, this part is there are reservation. And these two other points are that only arbitration agreements and arbitration awards made after the accession of the New York Convention will be you will have the New York Convention. And so the proclamation says that it will come into effect the moment it is published, which it has been published. But the question is, when is Ethiopia acceding? Now, according to the article on the New York Convention itself, it is clear that accession will only happen on the 90th day after the group itself has been deposited to the UNCITRAL. Now, the question is, we don't know when that has happened, and we're not sure that will happen anytime soon. There's no indications that that will happen anytime soon. So we are currently in a situation where we have the proclamation in force, yet have not succeeded. Therefore, there are no awards or that are currently being signed that will benefit from the New York Convention until the accession itself happens. So that is one major issue. Now, the other one is regard to enforcing this. So what's going to be very interesting is when you look at the current Ethiopian legislation with regards to awards and the New York Convention, there are some similarities, but there are also some differences. And the major difference being particularly with regards to enforcement. For example, the current bill requires that be a judicial assistance agreement between the countries from where the foreign award comes in. So if it's that Ethiopia and China have a judicial assistance agreement guaranteeing any award in Ethiopia and China. Now, Ethiopia has not signed many of these, so it's a very limited number. There's 4, China, Djibouti, and still intact, but I believe there's a Saudi one as well, and there's a third works. So that is one. Second chance is then if you are in a situation where you have an award that was rendered as the award as a force, but Ethiopia has succeeded, you are in a situation where you're going to have 2 different awards and 2 legal regimes pretty much being linked in, which is very difficult for courts but it's very difficult to establish a certain legal standard for how enforcement is going to continue. So I believe this to be a very challenge to courts.
All right. Thank you very much, Leyu. Your sound was breaking up a little bit. Your sound was breaking up a little bit, but maybe you can make a comment just to explain very briefly how enforcement of the how you see enforcement of the New York Convention in Ethiopia going forward. How you see enforcement of the New York Convention in Ethiopia going forward. Can you make a quick comment on that?
Can you hear me right now?
Now I can hear you.
Okay, perfect. So just to comment is that the challenge is going to be particularly on having two separate legal regimes, because if we're going to enforce the new convention, we're in favor of the proclamation that says the New York Convention will apply only provides the protection of the New York Convention or benefits of the New York Convention awards that have been made after the accession. Since the accession is not made, then we will have leaders court that is to be difficult for to award based off of the new regime, which is the New York Convention, but then the old regime, which is kind of commission, but not really, because challenges and glitches in the system there.
All right. Thank you very much. You broke off a little bit, but I think we got the point that the challenge is going to be having two separate regimes, one that is before enforcement of that is before accession to the New York Convention, and one that comes after accession of the New York Convention. I'll ask the IAC team to share the summary points that came from you on that. And as you can see from the summary points, Ethiopia's primary motivation has been to attract investment, and there are numerous reservations that will come into effect, and Ethiopia is revisiting its law to consider establishing an arbitration center. So if you have any questions, please post on the Q&A. Leyu will be answering those, and there are also Leyu's details are available on our IAC website for her to answer those questions. I'll now move on from Ethiopia and go down to a beautiful island called Mauritius, which has had quite a bit of experience recently when it comes to investment arbitration under the ICSID Convention. And I will welcome Mr. Johan Rajabali from BLC Robert to talk about Mauritius and in effect Africa's experience when it has come to the ICSID arbitration of investment agreements. Johan?
Yes, thank you very much. So the purpose of my intervention will be to focus on the latest ICSID awards involving Mauritius and Madagascar. So I will jump right in to discuss about Mauritius first. There has only been 3 cases involving Mauritius, all of which being very recent to the extent they have been concluded over the last 2 years. The first case being Rawat against Mauritius, which is actually the first ever case initiated against Mauritius. So the tribunal first asked to decide whether Mr. Rawat, as a dual national, could benefit from a protection of a French Mauritius bid. Now, the issue was whether a national in the French Mauritius bid included or excluded dual national, bearing in mind that the treaty did not provide for any express exclusion of dual national from its protection. Now, the tribunal sought guidance from a Vienna Convention on the Law of Treaties to interpret the term national and in accordance to the ordinary terms of a treaty in their context and in the light of its object and purpose. So therefore, the tribunal looked back at the provision of the French-Mauritius bid, where the term national were used, and noticed that express reference is made to the Exit Convention. Now, based on this, the tribunal referred to the Exit Convention, which contained a definition of a national, which expressly exclude dual national. So on that basis, the tribunal concluded that the explicit reference to the Exit Convention in the French-Mauritius bid was part of a context in which the term national must be interpreted. And therefore, the tribunal found that the treaty implicitly excluded dual national from the scope of application of a treaty, and therefore that Mr. Rawat could not benefit from its protection. Shortly afterward, there was the Dutroux-Moutwich case involving Mauritius. It came very much in the same breath of Rawat, and similarly to Rawat, the claimants brought this arbitration under the most favored nation clause in the French-Mauritius bid and the arbitration clause in the Finland-Mauritius bid. Now, Mauritius objected to the jurisdiction of a court, of a tribunal, pardon me, on the basis that there was no qualifying investment under the treaty, and secondly, that there was no consent from Mauritius to arbitrate under the French-Mauritius bid. Now, first, concerning the issue of what amount to a qualifying investment, but the tribunal recognized that the French-Mauritius bid did not provide for a substantive definition of what is a protected investment. So it applied the test of Salini, and while doing so, it found that there was no qualifying investment in the circumstances, to the extent that the claimant did not make any contribution of economic value to the host state, in the sense that it only makes some transfer from his bank account from France to Mauritius, and when his company closed in Mauritius, his fund went back to France. Secondly, the duration test as well failed on the basis that the funds were only in Mauritius for a very short amount of time, and thirdly, that there was no assumption of risk at all. Now, with respect to the issue of consent, the tribunal took the view that there is no general rule as to whether the most favored nation clause could apply to impose dispute resolution mechanism, but rather it is a question of intention of the parties. So what the tribunal did, it looked at the French-Mauritius bid and noted that there was only one important limitation. It only applied to matters governed by the French-Mauritius bid. So therefore, the arbitration clause found in the Finland-Mauritius bid could only be imported if the matter of that provision also governs the French-Mauritius bid. So since the French-Mauritius bid doesn't provide for a direct consent, but only a provision that any investment contract that an investor will enter with a state should include an exit arbitration clause, the tribunal concluded that using the most favored nation clause to impose such consent will create new obligation on the state, which it never actually undertook in the first place. So this could serve as a useful reminder that consent is fundamental to arbitration and to arbitration, pardon me, and that there must be clear and express intention to do so. The third case involving Mauritius is Gosling, which actually was delivered a few months ago. In that case, the claimant made some investment to develop two real estate projects in Le Monde and Pointe-Jérôme. They allege expropriation and breach of fair and equitable treatment on the basis of a change of policy from the government following the designation of Le Monde as a UNESCO World Heritage Site. Now, this is a picture of Le Monde and the subject matter of the project. Now, the tribunal in that case, by majority, found that Mauritius did not breach the treaty in as much as the claimant did not obtain the permits to develop his project at Le Monde, over which they could claim interference and damages. And similarly, the tribunal found that Mauritius, in respect to Point Jerome, was within its right to cancel the lease on the basis that the claimant has failed to comply with the obligation attached to the lease. Moving on to Madagascar, I will focus my attention to the Sutter case, which has been very recently refiled as an exit claim following a prolonged history of litigation between the parties. Now, what happened in the Sutter is they own a company in clothing, basically, and what happened is the company claimed damages following civil unrest in 2009 for some damages close to it. So following the local insurer refused to pay out, the claimant obtained judgment before the court for damages. Now, what happened is that the judgment was stayed following an application by the public prosecutor on the ground of interest of law. Now, the Sutter filed a claim under the Belgium, Luxembourg, Madagascar bid and governed under the ICC rules. Now, the sole arbitrator found that Madagascar had breached the fair and equitable treatment standard under the treaty through the conduct of a court, which appeared at the time more concerned with the interest of the insurance, which is actually owned by the state. Now, that dispute took another turn when the investors and the state argued the case before the French court, when the French would actually set aside the award on the basis that the sole arbitrator act in breach of due process by awarding damages which was not actually pleaded by the party, nor commented on by the state. Now, the Cour de Cassation also agreed with the Court of Appeal in that regard, and found that the arbitrator acted outside of his duties and powers which he was given. So, some 7 years after the claim was filed, initially, now the investors has refiled this claim against the state, but this time under the exit rules. So just to conclude, there's a overall recognition among African states that they need to provide a business-friendly atmosphere to attract investment, and in particular in line with the fact that the crisis that we are facing. So that comes basically with a solid legal framework and a robust dispute resolution mechanism to protect investors and guarantee the rule of law. And in many reasons, and for many reasons, the recent exit awards involving Mauritius and Madagascar are a testament to that. Now, I wanted to discuss about the role of Africa in the development of investment arbitration, but I realized that I'm maybe out of time, so maybe I will keep that for another discussion. Thank you.
Thank you very much, Johan. I actually have a follow-up question in terms of what you have on your last slide, which is Africanization
yes.
of arbitration awards. So if you can just put up your your last slide.
Yes.
Just your last slide. What I find interesting is what has been dealt with in terms of having innovative bids, such as the Morocco-Nigeria bid that imposes obligations on investors to comply with local environmental, social, and human rights issues. Now, what's interesting about that is that for various African countries, one of the issues that has brought about issues with investors has been the whole issue of social challenges and whether companies have a social license to operate. We certainly saw that in Cortec mining in Kenya. Do you think that that is going to, the whole issue of social and human rights laws being incorporated is going to be too wide-ranging when it comes to governments, I would say, having a free pass in terms of what they can be sued by investors on? That's number one question. And number two, on Africanization, is discuss a little bit more what you think about the Africa Continental Free Trade Agreement and how it Africanizes the whole issue of investment and investment arbitration.
Okay. I think it is very important that the new bids, the innovative bids, as we say, impose more obligation on investors to the extent that there need to be some balance between the right and the obligation of the state and that of the investors. Now, obviously, the Moroccan and Nigeria bid has been signed but not ratified, but it shows a good example as to the importance that the investors also focus on the local requirement of environment and social and human rights. I don't know if my fellow analyst has any experience in those, but I think it is the way forward actually to keep in mind the local requirement and to find a balance between the investment and the rights of the investors and the rights of the state, basically.
All right. Thank you very much, Johan, on that. Do you have any comment to make on the AFCFTA?
I think the time is ripe to find a common place for African countries. Now, obviously, we're in a time where we're facing some difficult time in regards to the COVID-19 implication upon the economies of the continent. So therefore, there's a further need to think local or even regional, I will say. So I think it is time now to think locally and try to develop in that sense, basically.
All right. Thank you very much, Johan, on that. EAC team, if we can have a slide on Johan's takeaway points showing on screen. As you can see, Johan has given us a very, very in-depth analysis into ICSID awards and how they've affected Mauritius, and they reassert Mauritius's commitment to protection and promotion of foreign investment. And of course, Africa continues to play an important role in the development of international arbitration. If you have any further questions, please use the Q&A portal that is on the link. Now, because of time restrictions, I will not ask for commentaries from panelists. I'll move on straight to the Q&A. But before then, I am told that there is a further poll question that will be showing on screen that is a follow-up to that. A follow-up that has brought about a lot of questions from the participants on, do you agree corruption is now widely prevalent in international arbitration? Do you agree that corruption is now widely prevalent in international arbitration? Please give us your answers to the poll question. Kamal Shah had to leave the webinar early. As I mentioned, he had another LCIA webinar to attend, but he will be very, very interested to see the audience's thoughts on corruption in international arbitration. And we are coming to the end of the poll. And the winner is that no, we do not agree that corruption is widely prevalent in international arbitration. So thank you. It's good to note the confidence that is there in international arbitration. I then move on to Q&A, and I would like to thank all my panelists for a great job, not just on their presentations, but also in answering the questions. Thank you very much to Kamal Shah from Stevenson Harwood. Thank you to Terry Mwango, to Madeline Kimei, Leyu Tameru, Johan Rajabali. We have several questions that have been answered. Thank you all for your questions. Thank you to Thomas Nguluma, Gide Asepa, Ben Sanderson, Samuel Rambo, Daniel Beno, Jackton Olachi, amongst others, Mary Angawa, Godson, thank you. We have some open questions, which I will address to the panelists. I will take the first one, which was the first to come in actually, from Alice Stoker in Vienna, asking the question on whether there are statistics regarding case numbers and industries concerned. And I will give the mic to Leyu Tameru to answer that question.
Thank you very much, Rayurmu, and thank you for that question, Alice. Yes, there are. I mean, that's probably what we've been doing at IARB Africa for about the past 4 years. For particular data, you can actually go to the arbitration centers themselves. Sometimes it's very difficult to find. They're not very segregated in terms of, you don't see what disputes are coming in from African countries, like what sectors are not. You just see a general perspective. But what we've done is we've collected enforcement of foreign arbitral awards, reviewed exit cases, and have currently developed an ISDS focused database concerning African countries, where they were, how much, what the final decisions were, how much it cost, who the legal representatives were, and whatnot. So we have that data. And it's difficult to bring together. It takes a very long time, but we do have that.
All right. Thank you very much, Leyu. And Alice, please feel free to log into iarbafrica.com, where some of that data is available. We have another question from Olagbeji Oloba Banke from Nigeria. Banke asks, how effective has virtual arbitration hearings been so far as compared to traditional hearing methods? Terry Mwango, I pose that question to you. In 1 minute, tell us what you think.
Thanks very much. I'll take less than 1 minute. I think I've answered the question on the chat. The same question has been asked by a number of attendees, but just very quickly, I think it's still very early days in terms of being able to see the effectiveness of virtual hearings. So for example, one of the questions that had been asked was in terms of, the assistance of witnesses. And what if, it comes to light later on that a witness had been assisted in terms of answering their questions? Of course, for example, if a hearing has only happened in the last month or so, it would be very difficult to know, unless that evidence is put before the court or the tribunal, whether something like that has happened. In my own experience so far, I think they have been effective. From an arbitration perspective and also from a court perspective. There are, of course, challenges, for example, technology and connectivity. I think things will only get better in terms of, for example, dealing with things like the standardization of platforms, and also being able to deal with challenges where parties can't be heard or not everyone in the room mutes their microphones. So on a scale of 1 to 10, I will say I think it's an 8. I think so far so good. There are challenges, yes, but I don't think that the challenges so far go to the root of the integrity of the proceedings.
Thank you very much, Terry. I'll post the next question to Madeleine Kimei. A question by Gide Asefa that was also echoed by Ben Sanderson. I know you answered it in brief on the group chat, but appeals on point of law, do they or do they not impede the whole principle of quick resolution of disputes? Please make a comment on that.
Thank you, Wairimu. And yes, now the appeal option that has been provided for under our new legislation, it really came about as a point of surprise, because if we look at our at the English jurisdiction now with the Arbitration Act of 1996, this has been a very controversial aspect of that act, and so therefore we're still yet to learn of its impact in the practice and whether it will slow down the arbitration process in terms of the awards being effected efficiently. Now, if you look at the Act itself, it does require for there to be leave to appeal. And so now we are relying on this provision that the appeal has to have been granted by the court. You need to seek for permission to lodge your appeal. That then is where we rely on the courts, on how they would approach that in terms of allowing appeals, because otherwise there'll be a floodgate of appeals if we don't control that particular option that is being provided for under our law. Along with that, there's also section 47 there, which talks on the errors of law and the option to appeal to the appeals court in the Court of Appeal. Now, that also is at the option of the court having had granted that appeal process to proceed. And of course, prior to that, there are certain steps that are set forth in the Act that practitioners should be aware of, and they're very comprehensively covered in the Act.
Well, thank you very much, Madeleine, for that. And thank you to all the panelists and the participants. We have come to the end of the time that we had allocated for this webinar. I would like to tell everybody who asked a question, I see there are still some open questions. This will be covered in the future webinars that we are going to have. I can see questions from Edward Luke, from Ben Sanderson, Elias Molel, Jonathan Hale, John Arthur, Thomas Nguluma, and various other participants. We have your details, we have your questions, and where possible, this will be answered by the panelists on email, and also in the summaries that we shall be posting. I also have a question as to whether the panelist presentations will be shared. Yes, the panelist presentations will be shared. The summary points that you saw coming up will be shared, and also Johan's PowerPoint presentations and any answers that can be answered by the panelists and posted to us will be shared with you. Let me take this opportunity to thank all my panelists, Johan Rajabali, Terry Mwango, Leyu Tameru, Madeleine Kimei, and Kamal Shah. Thank you also to our partners, Stevenson Harwood, Bowman Schoolson Honey, BLC Robert, a member of ALN, IAB Africa, and iResolve. Thank you for the support that you have provided and for being part of this first webinar. Thank you also to the EAC team in the background, GBS Africa, Slujan Events, IAB Africa, King and Spalding, Elodie Dulac. A lot of work went into making this, and I thank you very much. I would now like to hand over to Agnes Gitau, who is from GBS Africa in the background. She will be giving us further details about what to expect and about our next event, which is going to be happening very soon, but she'll give us further details. But again, just to thank all of you participants, please keep the questions coming to info@gbsafrica.co.uk or any of the organizers, and we will keep those in mind when arranging for the next webinar. Over to you, Agnes Gitau.
Thank you very much, Warimo. I echo you in thanking all our panelists, our partners, in just making our first webinar a success. What we expect next is we have a drink reception for our partners on the 27th of June, so next week. We'll send that invitation to you. And in this webinar, we'll be sharing with you sort of a sneak preview of how our program will look in August. So please look out for our email. And if you need more information on how to participate, please do write to us. So thank you everyone, and thank you for creating time. And we look forward to welcoming you back in August and next week for the drink reception. I thank you all.
All right, well, thank you, and we leave you with a nice little jingle from the EAC. Thank you all, and bye-bye. Thanks, Agnes.